one more interview. We have a very special personality with us, a very prominent personality, especially who has made a very big name in the field of service law, Senior Advocate PS Rajagopal, sir. Sir, thank you so much and welcome to this interview, sir.
Thank you.
To begin with, sir, could you just say a few words about your childhood days?
Except saying that if you look at my village even today, you would not believe that I could have marched so far having height from that village. There is nothing much I can say. See, it is such a primitive village. The population then was hardly maybe 600 or so. But variety of life was very much in that village. Out of that 600 population, there were Muslims. Hindus, of course, there were there. And one special significant thing about that place is there was a Christian family also. Moses, I remember. Normally, those days in rural areas, if you have to meet a Christian family, it will be available only when there is at least a local fund dispensary. Your nurses used to be from. In my village, there was no hospital, no nursing home, no private practitioner also in medicine. But still, there was a Christian family that I can remember as a unique point in my village, Karnataka. And for studies, it was a nightmare. There was a school which was then known as new type middle school. What is that new type? I am not able to figure out even today. Perhaps the new type was for classes 1 to 8, there were only 3 teachers. That may be the new type. Where a teacher will have to be managing more than one class at a time. And remember, those days it was not 7th standard was not the end of middle school, it was 8th standard. And at the end of 8th standard, we used to have a district level examination. And we used to be awarded a degree called as lower secondary. If we pass lower secondary, we have done something about that. And another thing about my village is that, except agriculture, there is no other occupation. Even today, there is no other occupation. And there was one masjid, one temple. But we never had any communal tensions. It was such a great mixture of cultures. Their major festival was Muharram, which would be celebrated for 9 days. And Hindus' major celebration was Ram Navami. They used to have Ram Saptah for 1 week, Ram Bhajans and all that. In both these celebrations, everybody from the village would participate. We would not know who is Muslim, who is Christian, who is Hindu. That unique culture of my village is something which we have to cherish, particularly in the present day. When I look back to my village life, I feel that whether I am living in the same country, in the same society in which I grew up. And after my marriage, when I took my wife to my village, first person eagerly awaiting me was one Madikade, all these, irrespective of their names, we call her Goma. She had told my aunt who lives there, when Rajana comes with his bride, first you inform me. And that lady, she was by then maybe around my age now. She came home, gave flowers to my wife and said, బాగుండమ్మయ్య because she could not talk even in Kannada because there is a foreign language. My village language spoken is Telugu. Bagundamaya Chanagirama. So that is the unique thing about my village. I would cherish for my lifetime, and I would like my future generations also should cherish that value. We made a society. We are all one. That is something very great about my village, which shaped my thinking. Then for education, I was telling that it is a nightmare. After 8th what? Nearest high school was at Chedur, which is 5 miles away. 5 miles away means literally 5 miles away, because there was no conveyance except one, Vijayalakshmi Motors. Vijayalakshmi was only in the name, but mostly it is to be a failed bus. Half the time bus will not be available. And we used to walk. Walking by road, it takes 5 miles. Then there used to be Kaldari, 5 kilometers. Either way we have to walk. Walking was our usual mode of conveyance to the school, which was 5 miles away. After SSLC also I could study there because one group of 3 philanthropists, they started a school. And from there, college, if you have to go, college is only at the district headquarters, Kolar. And one good thing about my education is I had no choice. Forget about this choice of school. Choice of section also was not there. Yesterday I was telling my grandson. We were 17 people in the 8th standard in the high school. In my batch contained 17 people. For 17 people, conducting one section itself is a costly affair. There is no question of, we were studying, grandpa, in another 1 month, this academic year will go on. Next year, my classmates will go to different sections. I told, what thing you are packing? I had no different school, no different section, only one class. Then college also no choice, because the entire district had only one college. That was Government First Grade College, Kolar. This is how our education scenario was. Today, children are spoiled for choice. And I see children saying, I am bored in this school, change me to another school. I don't know where from our children are learning these words. I am getting bored in this school. But the teachers I had were something unique. I always remember one teacher who I think shaped my outlook to life. Language teachers are always second-rate citizens, have always been second-rate citizens in our education system. I don't know why. Language means just English teacher, he is on a higher pedestal. Kannada teacher, he is always ill-treated amongst the teachers. He would be invariably a part-time teacher. Why part-time? Because all the 3 classes in the high school he also has to teach. Almost every day there used to be 1 hour of teaching in Kannada. At least 5 days in a week out of 6 days. That means he had a teaching workload of 15 hours a week. But he was a part-time teacher. But that commitment was something so unique. And those of you would be knowing, I don't know whether you had this Vyakarana and Chandas Shastra.
We had, sir.
You had, you were lucky to have that. Study of grammar, it was a disliked chapter within Kannada textbook. That was a disliked part of the language. One day one boy, my classmate, stood up and told, "Sir, Vyakarna test bರುತ್ತೆ sir marks. Means how many marks in question paper will contain on grammar?" Great man, my Kannada Pandit, Srinivasa ಅಂತ. ಅವ್ರ ಭಾಷೆಯಲ್ಲಿ ಹೇಳ್ತೀನಿ, ಅವ್ರು ಹೇಳಿದ್ದನ್ನೇ ಹೇಳ್ತೀನಿ, ಯಾಕಂದ್ರೆ ಐ ಕ್ಯಾನಾಟ್ ಇಂಪ್ರೂವ್ ದಟ್ ಲ್ಯಾಂಗ್ವೇಜ್. ಯಾಕೋ 10 ನಂಬರ್ ಇದ್ರೆ ಬಿಟ್ಬೇಡೋಣ ಅಂತಲ್ಲ, ವ್ಯಾಕರಣ ತಾಯಿ ಕಣ ಅಂತ. Grammar is mother. What he said was, mother of language is grammar. In later life I realized, mother of life is also grammar. See, after accidentally I joined the bank as an officer. And by choice I became a union director. It was because I found it unique that there was a trade union of officers. Normally officers, they say, are part of the management. But we had an officers trade union. It was quite vibrant union. And when the fight between the management and the trade union became very high intensity, what is the easiest tool that the management would pick up? Transfer the leaders. About 26 office bearers were transferred all over the country. I was also transferred to Davangere. And 2 of my colleagues from Bangalore, one was transferred to Bijapur and another was transferred somewhere else. All the 3 of us we questioned the transfers before the High Court, saying that it amounts to victimization. By now you know what will be the fate of any challenge to the transfer. Now of course in the government we have a transfer policy which the High Court has declared it to be statutory. Those were the days when transfer was considered to be a right of the management. So our petitions were dismissed. It was actually admitted for hearing, it was heard in a war footing, and we had an interim order also. What is the interim order? Not to take any disciplinary action till the case is decided. Once the case is decided, it will be treated as unauthorized absence and all that will be there. Afternoon 2:30 the matter had been listed for pronouncement. It was pronounced. It was against us. All the 3 of us were present in the court. I went straight to the railway station to book my ticket to the place where I had been transferred. My 2 colleagues, they went straight to head office of Karnataka to negotiate whether there is any chance of their being in Bangalore. My colleagues, honestly, they did not know where I have worked. Later I learned that they were searching for me, so that I also will be part of that conversation. I would not call it because negotiation can happen only from a position of strength. See, after losing, when we go for talks, it was not negotiation of rights, it was the negotiation of terms of surrender. That's why it is said, never negotiate out of fear, never be afraid of negotiations. These are the 2 principles in negotiation. Then management agreed to retain them in Bangalore. I did not waste any time. I booked the ticket same day for the next day's flight. Next day I traveled. Third day I reported it down. From there I telephoned my colleagues saying that, look, I have reported for duties at Davangere. They told, no, you did a mistake. If you had come with us, you would also have been accommodated here. Then I said, in life, grammar is not negotiable. arithmetic can be compromised. If I had negotiated and remained at Bangalore at the mercy of the management, I would not have been elected office bearer of a democratic trade union, but I would have been a member of management Kripa Poshita Nataka Mandali. Only Nataka Mandalis can be there. You see Kottureshwara Kripa Poshita Nataka Mandali, Sri Venkateshwara Kripa Poshita Nataka Mandali. That is where the grammar of life is important. Arithmetic is negotiable. If I am in Bangalore, I may save 100 rupees. If I am in Davangere, I may have to incur expenses to establish 1 year because my wife and child have to stay here. I have to be staying in Davangere. That is arithmetic of life. But surrendering and remaining at Bangalore, fighting and going to Davangere, that is grammar of life. This is where I always remember Srinivas, my great teacher. And he was never made a regular teacher. That is by the management. That's another reality of life.
Sir, you just spoke about your trade union stints and everything. But what chose you to become a lawyer? And
If I tell how I became a lawyer, advocate, I should say I am an advocate by accident. What was that accident? When I was heading the trade union in banking industry, slowly I came to realize that I only have passed in the bank and nothing much of a future. Remember, when I joined the banking industry, I was the youngest bank officer in the country, in the entire banking system. I was exactly 20 years, 6 months and 12 days old when I became a bank officer. There was no direct recruit officer in the entire industry at that time, and it was very promising. The career was ahead of me. And to tell you frankly, on the first day when I came out of the head office in the bank after reporting for duties, I just looked back and said, yes, one day I will walk out of this building as chairman of this bank. That was the confidence, and yes, you may call it arrogance also, I don't know, because I have been what I am and I cannot change. But when I saw the reality, I felt that in this suffocating servitude, commercial decisions cannot flourish, because bank being a commercial organization, we should have certain amount of discretion in taking decisions. And everything was chief huzur culture was. I should say that I was the first independent union leader in the banking research. My union was not politically affiliated to anybody. And there was a lot of freedom of thought and freedom of action. Sooner than later, I realized that my days in bank are numbered. At that time, one, I don't know, there is accident or coincidence, what it is. In January 1983, in 6 newly nationalized banks, a standardization exercise took place. I had a major role to play in this sense because I was negotiating on behalf of the two of those 6 nationalized banks. One is Vijaya, which was headquartered in Bangalore, and the corporation bank was headquartered at Mangalore. That took me to Kochi, Ernakulam one day, because in implementation of standardization, there were some problems in Vijaya. And I had the good fortune of meeting one evening there to brief a senior counsel by name, Mr. T. Senior. Normally, the senior counsels are not supposed to meet the clients directly. But he made an exception in my case because the General Secretary of the Trade Union on whose behalf I was going, I went there. His father-in-law and Mr. T.C. and Menon, both of them were underground prisoners in communist movement in Kerala. So because of that connection, he told my friend, you can come. Then we went. It was evening 6:30 or the discussion started with the advocate. Up to 8:30 in the night, I was explaining to him on this case. And look at his speed. He asked, you come morning at 8 o'clock, you are according to the morning 8 o'clock I read. TC and Menon was sitting on one side. Myself and my friend on the other side. He asked the young man, what are you doing in the lab? He said, I am in the credit department. I am recognized one of the better credit analyzers, and I got a lot of encomiums from the bank. He got bored. Yes, what the hell you are doing in the bank? And I was taken aback, what sin I have committed? He said, you should be here, not there. He told me that you would be better off as an advocate, and this profession needs people like you who analyze things. Then I signed, my friend signed the affidavit, we took Bangalore flight. First thing I did was getting down from the aircraft. I straight went to Vishweshwaram Law College because it was admission season. I took an application, came home, and I said my wife, tomorrow I am joining Law College for part-time course. She started laughing. That's how I became an advocate. By the time I lost my job in the bank this was open to me, and I became an advocate. And it was baptism by fire. I submitted an application. In that you have to, for enrollment application, you have to mention about your past employment and all. I wrote faithfully. I was working in Canara Bank as a manager. I was dismissed from service. I have filed a petition questioning the dismissal. I want to include. Then one member of the enrollment committee, he raised a point. Those times in law there was no subsequently a rule came. If a person is dismissed on a charge involving moral turpitude, he cannot enroll for 2 years or something. That is present. Those days that rule was not, and nobody can say that. You see, fighting for officers' cause is something involving moral turpitude. Of course, these days that is the thing. Anything talking something not palatable to ruling dispensation. It is a treason or what they call I don't know. What is sedition? Sedition. This sedition, I had not committed anything like sedition. Then he said, I had to give an undertaking, saying that I will not claim practice. Because he asked me a question, that enrollment committee. Now you have questioned the dismissal. You are enrolling as an advocate also. When the question of back wages comes, who will assess your income? The question was very weird. I asked, whoever is assessing your income, he will assess my income also. After all, to assess anybody's income, there is only one income tax department. It is not different between, because he is an elected office bearer of Park Council. He is not assessed by somebody else. And I am an entered to the profession, I am not assessed by somebody else. There again, grammar of my life. And then Mr. Arunasmurthy came to Mr. Arunasmurthy, even before he became senior advocate, he was not a senior advocate, he was my advocate for my union matters. As I was saying, the labor laws were divided on political lines. CPM unions would go to Mr. Keshav Rao. CPI unions would go to Mr. Ensign Narasimha. INTUC unions, they used to go to one D. Rajagopal. The Sanjay Nagar road, D. Rajagopal was there. That is named after him. And then came Leela Krishna. Mine was a non-political union. Where would I used to go to Mr. Arvind.
He was still an advocate then. He was not-
At that time, by the time I became an advocate, he had become senior. But he was the person, it had to be signed by two advocates. See, the application was signed, my enrollment application was signed by Mr. Narasimha and Mr. B.V. Mangappa, to whom Mr. Narasimha had introduced me. And I started my career in Mr. B.V. Mangappa's office, a great soul. They came and told Mr. Narasimha, sir, they are undertaking, they are asking me that I should file an undertaking, that I would not climb backwards. Then he told, no, don't give that an undertaking. If they insist, you tell that you have already filed a petition against Kerala, you want my filing another petition against Bar Council. I have been an obedient student. Next year, every Friday, this drama used to take place. Next Friday I went, what you have thought of? I told him, this is what I have thought of. Then he wrote the meeting, the matter has to be decided with the Bar Council, not with the Enrollment Committee. The matter was referred to for Bar Council, and that time when HR Patil from Dharwad was in charge. For 1 year, no meeting with the Bar Council. In the interim, the secretary of the Bar Council, the district, the rank person, he called me and told, Mr. Rajagopal, I cannot see you again. Why don't you make an application for decision by circulation? 120 rupees or 200 rupees, I don't remember. That was the amount to be paid. That I paid. Circulation, it went, everybody said yes, yes, yes. It again went to the person who had so told it should be decided in the full parliament. So he wrote, this is a dissent. And the circulation rule says once upon, even if one person dissents, it has to go before the meeting. Entire thing took about a year, and 1986 November I made an application for enrollment. I was enrolled on 19th November 1987. I don't want any young advocate to suffer that agony. 1 year, you do not know whether you will be admitted as an advocate or not. That is the uncertainty. That is how I became an advocate by accident. Then my enrollment itself was a 1 year affair. Enrollment. This is how I became an advocate, and lot of turmoil. The reason, I should say, how I chose to enter the law. Of course, my great-grandfather was an advocate practitioner in Chicago. But for the next 2 generations, we did not even have any inkling of law. My grandfather was not an advocate, my father was a Kannada teacher, and I started my career as a physics teacher. So it was also unplanned entry, I should say. And inspiration came from Mr. T.C. and then we should not surrender. That was a lesson taught to me, told to me by Mr. Narasimha, even at the time of enrollment. See, they are all great persons who have contributed. Our bar is respected. About reservation. In reservation, what was the issue? For admission to MBBS course, reservation in excess of 50% was provided by state of this. That was also argued by Mr. Venkataraman, M.R. Balaji. In Balaji's case, law is laid down, reservation cannot exceed 50%. Even today that is zero. That was in the year 1963. Some slight oscillating views were taken in the interview in between. 50% is not sacrosanct, it can exceed. And then one judge to the extent of saying that 100% reservation also can be done. How he overcame Balaji is, see, if you have made up your mind, you can give reasoning to justify any conclusion. When Balaji was pointed out to the judge of work, the question was very simple. Whether a single post can be resolved. If you apply Balaji, it cannot be. Subsequently, Chakradhar Paswan had come, which had reiterated there cannot be 100% reservation. To overcome that, a very strange logic was propounded by one judge, which said, you will fill up that post by rotation. In the first post, it will go to reserve category. After his retirement, the post becomes second time vacant. Then we give it to general merit. Therefore, it will be less than 50%. This type of arguments for all aberrations had all cropped up, but ultimately, larger page judgment in Indira Sani, it reiterated Demar Balaji, and today Balaji is the law. Not about the longevity of Balaji, but about the legal values are propositions which are time resistant. They have no expiry life. There is nothing called as shelf life. When these judgments are looked at, they have no expiry period. They are legal values and judicial principles which are valid for all times to come. Then, importance of representation by an advocate in a judicial proceeding. See, like until 1975, right to property was a fundamental right. 42nd Amendment took it away, but introduced Article 300 capital A, which made it a constitutional right. In the Land Reforms Act was intended to as a socio-economic development of the weaker sections. That is, a realization came that social development can take place only with economic strengthening. And how do you strengthen economically, financially a poor man? Land reforms was part of a measure where tiller would become only. And one important aspect was that advocates cannot represent the parties before the land. That was the provision. That was struck down. That was also argued by the attorney.
Sir, why was he called as this writ timer?
Because this is writ was a right given to us under the Constitution. And he propounded for what purposes that it can be used. For example, in Balaji, by a writ, you can strike down an act of the executive which violates your fundamental rights. What is the fundamental right? Right to equality. Right to equality, if it is breached by the executive, how do you make the executive action nullified, or how do you strike down the executive action? By issue of a writ. if it is a law which is unconstitutional, a writ would be issued declaring that law to be unconstitutional. If there is a quasi-judicial order which is unconstitutional, which is contrary to this law, certiorari would be issued. Or in a case where something is being done without jurisdiction by a judicial body or a quasi-judicial body, prohibition will be issued. All these were writs which were given to us by the Constitution, and Constitution would not work by itself. It requires a Venkataranga to make it work. And he made the law of writ to work. One thing was, he was the leader of the bar at a time when the writ remedy was being tried in the country for the first time. Because before Constitution, no writ was available. Constitution was brought this remedy of writ. And that remedy was activated by doings of the bar like Mr. S.K. That is why he is called as retired. Because law gives a remedy by the process of making the law work. He is the person who made writ remedy work. That is why perhaps he is called as a retired. In fact, I had the good fortune of seeing some of these great ways of Mr. V. Krishnamurti on the civil side, who would, and then Venkataranga was arguing even before the Karnataka administrative tribunal. One matter was there about a Sanskrit teacher who had been dismissed or something. Mr. S. He was the government advocate for the tribunal. Venkataranga appeared for the applicant. Even before he could open his case, Yashwanath decided that no, he was not eligible, and then we have done it correctly, we have dismissed him. Then look at the presence of Narasimha. 100 ಜನ PhDಗಳು ತಂದು ನಿಲ್ಲಿಸ್ತೀನಿ ಫಿಸಿಕ್ಸ್ ಮ್ಯಾಥಮೆಟಿಕ್ಸ್ ಅಲ್ಲಿ, ಸಂಸ್ಕೃತ ಒಬ್ಬನ ಕರ್ಕೊಂಡ್ ಬರ್ತೀನಿ. That is how he made the intermediate work. See, not only the knowledge of law, but knowledge of life, knowledge of societal realities, all these were made. Those days, when we go to the association during lunch, you would see a high value discussion about law, legal principles. You will put it in you are all new entrants like kindergarten children. Even we could go on Bayoro. But they were great. Then various values of these great men of the province. Recently we saw a judgment render, even though we did almost on a day-to-day basis. Justice Abhay Gopal was our Chief Justice. Some resolution passed by some bar association that nobody will defend a particular person in criminal cases. That type of resolutions, and then Chief Justice had to correct it. How corrective forces were there? Because one thing we should always remember is advocates we should not be allowed to be regulated by outsiders. It is a noble profession comprising of eminent members who have a larger societal perspective. When such noble membership is there for the bar, are we not capable of regulating ourselves? Should we be regulated by some outsider saying, yes, I can't say Chief Justice is an outsider, stricto sensu, but he is outside the bar. He is on the bench. Should we require a bench to regulate our conduct as bar? Can there not be any corrective forces from amongst ourselves? Why should we pass such a resolution at the first instance? Because right to be defended by somebody is a human right. Even Kanun Guru Munchana right it. It is not a right given to us by law. Even Maneli, ಯಾರಾದರೂ ಬಂದು ದಂಡಿಸ್ತಾ ಇರ್ಬೇಕಾದ್ರೆ ಒಬ್ಬರಾದ್ರೂ ಬಂದು ಅವ್ರ ಮಗುಗೆ ಡಿಫೆಂಡ್ ಮಾಡೋರು ಇರ್ತಾರೆ. See, right to be defended is a human right. I see now, I don't know whether Rashid murder case it was a major case because Ramakrishna English government was the first non-Congress government in the state. And then luckily there were no this 24/7 news channels. That was one great redeeming feature there. The question came, in Rashid murder case, Rashid was from Kerala. It all started when he wanted to establish a medical college and also many intricacies we not know. In that, Mr. A.J. Rajagopal, who was an advocate, later he became chairman of our advocate, president of the Advocates Association, something like that, and he became a judge of our Sadashiva was to appear for one of those items. Then association took a stand that nobody should defend the accused. Then it was Mr. Arvind who said, everybody has the right to be defended. One cannot take such a infantile stand or a juvenile stand. We are all mature members. And after all, any advocate can take such a stand. That is not the greatness. Greatness is he resigned from members of the association. That also I will not say as a great act. But he said he stopped utilizing the advocates hall. After all, hall is provided by the association, by the High Court for advocates to rest. You would not enter that hall because he said, no, Mr. Gopal, I cannot enter the hall. That is provided by the High Court to the Advocates Association. I have resigned from the membership that is, therefore I cannot utilize the facilities given by the High Court because it is given to the Advocates Association. Through that, advocates may benefit, that is different. And he used to stand outside the bench. Have carried over the bench. Another thing is, you see, each of the persons has such sovereign qualities. My senior, Mr. B.P. his drafting is something super. As a government advocate, he used to write by hand the objection statements, meeting every sentence in the repetition. Morning he would come and hand it over to the with the AG's office for time. That's where drafting I learned from my senior. Sometimes it will appear to be very verbose and all. No. He had a method. He would deal every single hour. If you read his written statement, the statement of objections is there. You can argue the case. Nothing else you need to take. Then we had, say, in our law, persons like Mr. Keshav recently expired. He was a diabetic for long years. More than once it has happened. If the diabetes is uncontrolled sugar level or some sort of infection, there is common thing is ketosis. He has been admitted to Mayanas. One day there was a matter which required his urgent presence in the court. He took permission of the doctor, a very nice doctor. He was his personal friend also. So he could not have perhaps said no to him. ಅಥವಾ ಇವಾಗ ಇನ್ಸಿಸ್ಟೆನ್ಸ್ ಜಾಸ್ತಿ ಆಗಿ ಆಯ್ತು ಹೋಗ್ಬಿಟ್ಟು ಬನ್ನಿ ಅಂತ ಬೈರೆ ಕಳಿಸಿದಾರೋ ಗೊತ್ತಿಲ್ಲ ನನಗೆ. He came from the hospital, argued a matter, got the stay, then he went back to the same hospital bed. Next hearing matter, I asked a time on his behalf. So senior. But again, in the morning he got a stay. What is the difficulty for him to argue? Then I put him in court. I don't say I had been admitted in the hospital. From the hospital bed, for the sake of this poor workman, he came to the court. He has gone back to the hospital. Then the next question was, what the hell you are doing here? If your senior is there, you go. See, that is the level of commitment. After all, a workman in difficulties, in the best of times, he cannot pay your fee. When he is in difficulty, what is the amount he can pay? Payment is not the criteria. Payment you will get when he is in a position to pay. But service you should render when he is in need of it. That's what Mr. Keshav stood for. And I have seen then we have, always if you ask my colleagues, they will also be of the same. These seniors are born only to scold the juniors. What the senior does, we organize the files, we take the papers, we tell him in the court what he has to tell, then he repeats to the court what we have told him, he gets the fee and we get the scoldings. Am I right?
Correct.
Generally, we are the villains, and I have no exception. In my presence, they may say no, but I know what they would say in my absence. But one person who was the exception to this was Bishop Silas. Even when the juniors were most irresponsible, I would not say wantonly, but not knowing the consequences, he would be smiling. He would tell me, hey Rajagopal, come here. This book, this bag of the Indian ID Act is called. Then come go sit there in Kolkata. But I know his colleague was not present either because his their mistake, he would not bother for all this thing. And another greatness of President was that most of these they were lawyers. They were guilty of one thing those days. So I don't know. They know that when the dismissed workman comes to file, raise a dispute, he may not have money. So they will file. And they have a share in back wages. One advocate who resisted and who never did that was Vishnu Singh. This I hear from, this I learned from an advocate appearing for the management in that very case, and back wages Bandaka. He sent the amount to Mr. M. Singh's office because he knew that workman would not have paid. But when Mr. M. Singh said, "None can be trusted as well, or this is the values. In a particular case, they are not. We need not be afraid of the risks. As long as we have that inclination to work. Capacity every human being has. What makes one less capable is lack of inclination and not lack of capacity. Capacity is always there. And within, I can say I enrolled in 1987. At that time, my wife was working as a bank clerk. And she told, I have to continue in employment because we do not know how we will practice will pan. Within 5 years, my financial position stabilized. So 1993 beginning, she resigned from the job and said that now this family does not need my financial support. What it needs is my support, being a good mother and a caring wife. Then she resigned. I told her, you continue for another 7 months. Pension settlement is coming in the bank because though I was an advocate, I was still in advising the bank units. Then she told, I don't want pension. I want to bring up my daughter, and you are a chronic diabetic. I want to take care of you. Therefore, 7 years, what Mr. P. Narasimha Rao said, or what we generally believe, is not a sacrosanct or inalienable deadline. It happened to me in 5 years. For some other lucky people, it may happen in 3 years. For some unfortunate or lesser privilege, it may happen in 10 years. But this profession will never let you down. That much I can tell. And that confidence is very, very important.
It would be a great message to the struggling lawyers.
No, not message. Because we see, this is the reality. What happens is, when I enter the profession, I see so many people in the court, and hardly 15 or 20 of them standing up every time, are in any court. Then it is in this profession there are already so many people without a voice. I will be another addition to the voiceless. No, it is not like that. Maybe the court needs your voice. That is why others are silent. Develop your voice. And more important is because these are all some things we learn in law books, we go to later. But then, what is frightening today is our lack of interest in literature. Knowledge of our pursuing study of literature is very important at any stage of our life. Today what do we read?
If I ask, what is the, other than law book, what you have read? Justice Krishna Ayer's Reminiscences. That is again law. Read something which is not connected with law. That would be something that would be shaping your arguments also and your skills also. Go to Julius Caesar. People would have rebelled against the king. There is no support. Nobody is even willing to listen to the king. He is a, what I say, anti-people despot. One Mark Antony. How he turned the case. Only if you read Mark Antony's speech, you would know what is advocacy. Bench is hostile to you. He does not want to listen to even one word what you are saying in support of your client. How do you start? Yes, my learned friend is right. They are all honorable men. That is what Mark Antony said. They are all honorable men. After saying that, slowly by a process of reasoning, he turned the tide, quelled the rebellion. Where do you get this skill? You won't get on YouTube. Yes, in movie type you may see it happening, but read it so that you will feel what is happening, you will imbibe it in your psyche. Knowledge of literature, particularly contemporary literature, if you read, over a period of time, evolution of literature, it will also give you an idea how the judicial values also change from time to time. Novel, it is not a real life story, it is a fiction. Even that fiction will teach you how the life evolves, how a person would react to a particular situation. For us to understand the case, most of the time, what happens? They say, the petitioner knows what is the truth. Respondent knows what is the truth. Only person who does not know what is the truth is the judge. So it is the judge who is on trial to find out the truth. This, how the judge will be able to know the truth? By a process of visualizing, if this is what is taken, what would be the real pain behind it? Or you can say, particularly for practitioners of law, behind every case or every case paper, there will be a human story behind it, which neither plaintiff will tell you, nor the defendant will tell you. Sometimes to conceal the truth. And more often, they would not have been able to analyze what has really happened, why it happened. This visualization, you would realize only by constantly reading literature, because literature gives you a immense knowledge of human behavior, realities of life. I always say, suppose Kaikeyi is put.
Sir, could you please tell us about your initiate days of practice, the saga of from becoming an advocate to a senior advocate?
Becoming a senior advocate from being an advocate was not something, but remaining as an advocate was a challenge. Because when we enter practice, what is the first thing we do? To whose office I would join? Where would I begin my journey? And it has more than one significance. Because my life as an advocate has taught me one thing. You are made or marked sometimes by the office you join. Suppose you join an office known for sharp practices. You would also be trained in the same way. Then your acceptability in the bar also becomes a question. Who is whose he is? That is how they will talk in us. And if your senior is a very respected, oh, he's junior of so and so, you are working in such office. Come on, even there will be a smile. That is one aspect of the matter. Another aspect of the matter is finances. Most of the seniors, including me, Margaret, including me, we don't pay the colleagues what they really deserve. Because of two constraints. One constraint is our own love for money. Second is the wooden equality we would like to follow. Equality before law, we carry to such an extent. I pay that boy with 5 years experience only this much. How can I pay this boy who has entered my office just last year more than that? Yes, over a period of time they will get sorted out. But one thing I can tell you, in terms of my experience as an advocate, first as a junior advocate, my senior had given me enormous freedom to argue the case. And that I have developed. And I also in my office, everybody is given freedom to, no file is kept under lock and key. And in fact, when an argument note is prepared, I share with all my colleagues. Not that I am passing on the knowledge to them, but that is with an intention to get, do I have any solution to improve this? Please let me know. If I get feedback, sir, you have omitted this point, I would be very happy on that day. Because two things. One is I am unlikely. Second is my client's interests are that much better served. And third and most important is my colleagues are seeking to know what is new. That way, my senior had given me enormous freedom. But when it comes to finance, the difficulty was, most of the time my senior used to appear to organize the bodies like KSRTC. Then if he gets something in cash, he can share with me. Where would the KSRTC give cash? No. Therefore, I had my trials as an advocate. But it was not as frustrating as it would happen to most of the advocates. Because I was telling you that I was a bank officer, then a trade union leader, then I became out of victimization, forced me to the profession, all these things I was done. Therefore, on the day I entered the profession, though my banking career had robbed me of 14 years of practice, it was not a waste. Because I knew so many people, so many trade unions. They would come. First, yes, our comrade is there, there is no one advocate. So they would, first choice would be Rajagopal. Because I can understand their idiom. Then he knows the rules. At least he has handled the rules by the ground. Therefore, he would be better at it. Therefore, For me, there was no depth of practice from day one. That would not be the position with respect to most of the advocates, because they will be building from scratch. And for them to be known in the profession, it takes considerable time, because even today I find most of the advocates, they would not allow their juniors the freedom to act. If senior has not come, they have to seek perforce adjournment only. If senior is held up in some other case, they have to, their only instruction is seek passover. Passover advocates and adjournment advocates. This is really frustrating. What the advocate requires at that stage, a sort of encouragement. What is the encouragement? In one matter, I had briefed Mr. PP Rajagopal. At our instance, matter had been agreed to be taken up for out of term leave. So Mr. PP Rajagopal said one thing. In the first round, when it reaches, seek passover. Second time when it reaches, you don't seek passover. You tell that Mr. PP Rajagopal will join us and you start. Whatever manner you can be proceeding, you keep the court engaged. That is the first thing whichever younger members they record. Don't say that you delegate, you abandon your functions and ask to do. No. Tell them that I am not irreplaceable. After you have read the file as much as I have read, you start. That is what gives them not only the courage, but a feeling that, yes, today my senior has said you start. Though in my absence, that means he has confidence that I can start. This waiting period is so frustrating. One is finance, after all nobody can thrive on empty stomach. On empty stomach, only one thing can happen, that is Naxals or the revolution. Life most of the times is not revolution, it is evolution. Therefore, we have a duty to help the colleagues to evolve, not revolt against. And number of times, the financial wants it is so frustrating with this one. Why not I leave the profession? Or why not I join so-and-so as a law officer? Because as a law officer, life is easy. You need not know the law. You should know the lawyer. You would have known the lawyer by being in the corners of the court for 2-3 years. Therefore, you become a law officer. What is your duty as law officer? Carry the file, come the company to the lawyer. Take his opinion, bring it back. And you will be paid salary which is much more than what you can expect to earn in the first 10 years of your practice. But it will remain at that level forever, you will be. In the profession, as famously put by many people and effectively put by Mr. P. Rajagopal, after he demitting his office as Prime Minister, he once addressed our association is that in this profession there is what is known as 7 years each. Life will be so frustrating. One day you will get scolded by the judge. You feel, after all, after studying for so many years, why should I get scolded by this fellow? I resign or I go. No resignation is also required in our profession. Just to hang up your books, that's all. Sometimes you will see seniors enjoying a nice drink and all that and food and they will not even bother to ask you, have you had anything? Why should I stop to make that man enjoy life? All these frustrating thoughts come. But I was lucky enough not to get sick because I had a very kind senior. And I had a good beginning because after a few years of my becoming an advocate, the chairman of my ex-bank, my ex-employer asked, yes, I am told you are flourishing in practice. Then I answered immediately because one thing I remember is, I always believe is, every question has to be answered, except where it is a weight ball. So I told, yes, Canada Bank gave me a lot of courage because without courage I could not have fought you. And the Canada Bank Officers Association gave me enormous contacts because of my being a union leader, more so as the All India Confederation of Bank Officers. It gave me enormous contacts. Contacts are getting me cases. Courage is making me argue. Therefore, the combination of contacts and courage I am putting to good use. I am always grateful to you, sir, because you are the person who signed my dismissal RGA. But everybody may not be that fortunate. But we should remember that adherence is the practice of law. Beginning would be very, very trying. Don't allow those disappointments to overtake you. Have faith. Faith in what? If I work hard, one day or the other, cases will come. Your visibility in court. Suppose somebody doesn't come to the court only because he doesn't have a case on that day. There are better places to walk around. I have no case, why should I go? No. Because your visibility is one thing, first thing that makes you acceptable to the clients. You may have a case only at 4 o'clock in the evening, but be in the court in the morning. Mr. H.J. Sundaraswamy was one such senior advocate. He would be in the court by 10:30 in the morning. His case may reach only at 4 o'clock, but visibility. Visibility gives you 2 or 3 yields. First yield is the court would know you are a disciplined advocate waiting for your turn. Second is client would know my advocate is always present to protect my cause. Third is, this is very important. Being in the court hall is itself an education. You would see wide variety of people arguing. Learn, see what they are arguing. Most of it we may not know because the person arguing would have read that branch of law previous night. You might have read it 1 year ago, or you might not have read it, or we might have answered a question on that in the LLB examination, thereafter forgotten it. Because being in the court is the first essence. And when you are busy imbibing or absorbing what is transpiring in the court, it would keep you away from frustration. Because if you sit in the advocate's association without any work, one knows me, that itself will add to your ways. I have undergone all this. But even when underemployment period, I would say, it is not unemployed because we would have enrolled during my underemployment period. I used to spend time in 2 places. One is High Court Library. And the clerks there, or even the peon there, would be so happy to see me. You come and which book you want? Because books are there, nobody is reading. He is so eager, somebody should take and read it. Now we don't, of course, we say we go to website and find it. Go to the book. Because without diversion, you can be studying. Second is, I used to spend time in Vidhan Saudha library. There is one legislator's library is there. It is such a treasure house. You will get every parliamentary committee report. You would get proceedings of every debate in the legislatures. You may say, today what is being debated for you to read? There is nothing being debated. That is one way. If you don't find anything good in the present day debates, go to olden days debates. You would at least know how the constitutional law has evolved, how various acts have been promulgated, why they are promulgated. Because knowing the law is one thing. Knowing why of the law is most difficult. And then you are a jurist if you know why of the law and not content with what of the law. What we can read, why we have to learn. Once you engage in this process, the initial disabilities will not frustrate you. On the other hand, it will help you resolve them. Of course, the life of a beginner in profession has to be made comfortable. How much comfortable? It should not be so comfortable that even without learning I can manage. No. Comfort should be enough to give you strength to pursue, but it should be slightly less than the adequate level to keep your hunger for knowledge and hunger for work intact. Only a hungry man will work. Not that he is starving. It should be above starvation level, but slightly less than level of luxury. And I can say the professional workload that. Of course, there will be some extraordinary circumstances like COVID. Almost 1/3 of the advocates in Bangalore from rural areas, particularly who were in the first 5 years of their practice, they gave up practice and went back to their villages. That is a disastrous situation. But life is not always a disaster. Why we call it a disaster? Because it is a passing phase. Life is a pleasant thing and it has to be lived and enjoyed. Every beginner in the profession, I would not call them a junior because I always consider myself an aged colleague. They are my younger colleagues. I would not even say that they are junior colleagues, I am senior. I am an aged colleague, they are younger colleagues. Younger colleagues should be told one thing. I always take pride in this fact. At the end of the marathon, because life is not a 100-meter sprint, it is a marathon. At the end of marathon, where I was born, as what I was born, what were the difficulties I had, as what was the situation in which I was born? They are irrelevant. Ultimately, life is what I make it. If Jayant came once along with me to my native village. For about half an hour he did not open his mouth. Normally he doesn't open, so I did not take it as something abnormal. Then I asked him, "Kya suna idea?" Sir, he hardly looked in using an advocate. Then I told him, in the constitution there is no prohibition that a boy from Polycarp should not become a senior advocate. Luckily, that is not the law. Life is what we make it.
And one fantastic thing about this profession is, advocate has a greater freedom to shape his life. Greater freedom, in the sense, the choices are plenty. Choices means what? Whether you would go for a sedate stability or an uncertain dynamic growth. Uncertain dynamic growth we can take in this profession with lesser risk than in stock market. We need not be afraid of the risks. As long as we have that inclination to work. There is capacity every human being has. What makes one less capable is lack of inclination and not lack of capacity. Capacity is always there. And within, I can say I enrolled in 1987. At that time, my wife was working as a bank clerk. And she told, I have to continue in employment because we do not know how we will practice this paramount. Within 5 years, my financial position stabilized. 1993 beginning, she resigned from the job and said that now this family does not need my financial support. What it needs is my support, being a good mother and a caring wife. Then she resigned. I told her, you continue for another 7 months. Pension settlement is coming in the bank, because though I was an advocate, I was still in advising the bank units. Then she told, I don't want pension. I want to bring up my daughter, and you are a chronic diabetic. I want to take care of it. Therefore, 7 years, what Mr. P. Narasimha said, or what we generally believe, is not a sacrosanct or inalienable deadline. It happened to me in 5 years. For some other lucky people, it may happen in 3 years. For some unfortunate or lesser privilege, it may happen in 10 years. But this profession will never let you down. That much I can tell. And that confidence is very, very important.
It would be a great message to the struggling lawyers.
No, not a message. We see, this is reality. What happens is, when I enter the profession, I see so many people in the court, and hardly 15 or 20 of them standing up every time at the Indian court. Then it is oh, in this profession there are already so many people without a voice. I will be another addition to the voiceless. No, it is not like that. Maybe the court needs your voice. That is why others are silent. Develop your voice. And more important is because these are all some things we learn in law books, we go to it, but then what is frightening today is our lack of interest in literature. Knowledge of our pursuing study of literature is very important at any stage of our life. Today, what do we read? If I ask, what is the, other than law book, what you have read? Justice Krishna Ayer's Reminiscences. That is again law. Read something which is not connected with law. That would be something that would be shaping your arguments also and your skills also. go to Julius Caesar. People would have rebelled against the king. There is no support. Nobody is even willing to listen to the king. He is a, what I say, anti-people despot. One Mark Antony. How he turned the case. Only if you read Mark Antony's speech, you would know what is advocacy. Benches first time to you. It does not want to listen to even one word what you are saying in support of your point. How do you start? Esmeros, my learned friend, is right. They are all honorable men. That is what Mark Antony said. They are all honorable men. After saying that, slowly, by a process of reason, he turned the tide, quelled the rebellion. Where do you get this skill? You won't get on YouTube. Yes, in movie time you may see it happening, but read it so that you will feel what is happening, you will imbibe it in your psyche. Knowledge of literature, particularly contemporary literature, if you read, over a period of time, evolution of literature, it will also give you an idea how the judicial values also change from time to time. Novel, it is not a real life story, it is a fiction. Even that fiction will teach you how the life evolves, how a person would react to a particular situation. For us to understand the case, most of the time, what happens? They say, the petitioner knows what is the truth. Respondent knows what is the truth. Only person who does not know what is the truth is the judge. So it is the judge who is on trial to find out the truth. This, how the judge will be able to know the truth? By a process of visualizing, if this is what is taken, what would be the real pain behind it? Or you can say, particularly for practitioners of law, behind every case or every case paper, there will be a human story behind it, which neither plaintiff will tell you, nor the defendant will tell you. Sometimes to conceal the truth. And more often, they would not have been able to analyze what has really happened, why it happened. This visualization you would realize only by constantly reading literature, because literature gives you a immense knowledge of human behavior, realities of life. I always say, see, suppose Kaikeyi is put on trial, Putra Viyoga, separation from the son. Most loved son of Dasharatha was Rama. So separation of the Rama from Dasharatha can happen two ways. One is Rama's death. Another is banishing him to forest. So Kaikeyi thought of a plan to save Rama, because in the moment of death of Dasharatha comes, Rama has to be out of the sea. It can happen only two ways. Either send him out or face his death. So Kaikeyi wanted to save Rama. Therefore she asked her husband, make my son king. And not stop at that. Send him away to forest. Suppose I am appearing for Kaikeyi against charge of abatement. Is this not a good defense? This you can learn only from literature.
and not from reading Criminal Procedure Code or Indian Evidence Act or whatever the new names are. And remember what all things these literature can teach us. See how it can help us. Normally, when we say that after all it is written in our fate, or life is like a stage. It is preordained. You only act on those. Improve it a little further. Go to TP Kailasam. TP Kailasam improved this. ಸುಸ್ತಾಗಿರೋ ಪ್ರಾಣಿ ಸುಧಾರಿಸ್ಕೊಳ್ಳೋಣ ಅಂದರೆ ಸ್ಟೇಜಲ್ಲಿರೋ ಸೈಡ್ ವಿಂಗ್ಸು ಇಲ್ಲ ಈ ಲೈಫಲ್ಲಿ. ಅಟ್ಲೀಸ್ಟ್ ಡ್ರಾಮಾ ಈಸ್ surreal. If an actor is tired, he can go to side wings, have a cup of coffee and come back. Now you can shoot, can resume shooting. Life, it doesn't have side wings. See, this realization helps us imagine things better, and it would help us think much better. See, one advocate whom I admire and who was an expert in this is Mr. PP. Though I am in Bangalore and he was in Delhi, somehow I developed that good relationship with him. He was one such person who would, even while brief, immediately bring some literary work and then why not we think on these lines. One glorious thing about him was this, about that Abdul Rahman Abdul's case, Abdul's case. Pratibha, Indira Gandhi Pratibha Pratishthan. That was the trust established by Anthony as Chief Minister of Bombay, Maharashtra. Then it was calculated the donations received by that trust were a multiple of the cement bags released to the contractors. So they could link and say that for every bag of cement, because cement was a controlled commodity, for every bag of cement you have taken this much price. You have not taken it for yourself, of course you have collected it in the name of Indira Gandhi. 5-judge bench, the principal issues who is the competent authority to sanction and all that. Then that had become redundant by the time the matter was decided, they had ceased to be issued. Then out of its anxiety to ensure speedy trial, Supreme Court ordered he should be tried by a special court, which is the Bombay High Court. Thereby what happened was, he would be tried under Prevention of Corruption Act by a judge of the High Court, thereby taking away his right to appeal to the Supreme Court, to the High Court, and then he will have to have only one decision. 5-judge bench decided. This point, that is, to be tried by a special court, was never argued. The judgment was rendered in the presence of all the advocates, all the parties. Then in the second round, a review of that judgment was sought on the ground. 2-3 grounds were there. One is Supreme Court has made the law, because it is not a parliamentary recent enactment to say that he should be tried by special court. Supreme Court made the law. Second is, on this issue of being tried by Supreme Court, by the High Court, there was no argument, no pleadings,
Point was not put to anybody, just they just decided. Therefore, the review was failed. In the review, a 7-judge bench reversed that decision and said, yes, a citizen of this country has a right not to suffer a judgment contrary to natural justice. When the court has to follow it. This point was never put. Though every party was represented, every party was present, this aspect was never put to the party, therefore they had no opportunity to argue. This again, thought of fairness is something that is deep rooted in our literary works over a period of time. Any number of literary works we will find. They come to conclude sometimes, he was treated unfairly. Unfairly what? Hanging without hearing. Again I go back to Ramayana. In my avatar as a trade union leader, I was participating in one training program at Administrative Staff College of India. It was titled Effective Trade Union Management. So one question came up in the group discussion. After all, the officers are part of the management. Why do they need a trade union? My answer was very picked up straight away from the literature. We are only part of management as officers. Sita as queen was part of the ruling clique because I believe king and queen rule together. Whatever ministers may advise, ultimately it is the advice of the queen in the bedroom that goes into the mind of the king. Therefore, Sita was a part of the ruling clique. But she was banished to forest without a hearing by Rama. On the word of a hearsay statement of one Dhobi, this would not have happened if the housewives had a trade union in Ramayana. Is it not an acceptable argument? Where from you get this? It is again from literature. So my appeal to you is, whatever may happen in the court, you have to get ready, that is different, but then devote some time to literature. Literature means not WhatsApp literature. Literature means literature which is written and printed. It will give you enormous reality perception and it will change your thinking itself, which is necessary for our progress in profession.
Sir, if you want to give one message to the bench or one message to the bar, what would it be?
Bench or bar?
Bar and bench.
I will start from the bench. Bench should be receptive to the experts, because what they need is an assurance that they would be heard, not that they would be rewarded with a relief. If there are no case, be merciless, no problem. But don't make an young girl or a young boy go to the court. When if senior had come, they would have heard, they did not hear. Because after all, without freedom of speech, there is no civilized society. And what any advocate craves is, please hear me. And on whose behalf he is telling? Not on his behalf. There is an aggrieved soul, please hear him through me. Intolerance should be the last thing that bench should resolve.
They may sometimes feel this man is wasting the time. No, sorry. It is not wasting of the time. There is a way to bring the advocate to come to the point if he is deviating. And that way is not shutting his mouth. That is the only, I would not say message, that is the only prayer I can deliver to the bench. To the bar, remember one thing. Client has paid you to put forth his case. If you win, you will be happier. But he will be happy if you make his case heard. When can you make his case heard? You understand his case. Try to find the best argument you can put forth in his favor. And if it is a non-winnable case, at least reduce the intensity of his suffering. At least smoothen the rough edges so that he will not fall on thorns, he may fall on the flat ground. If you do this, then your growth is assured. You would have worked as an advocate in the cause of human problems. Because all these acts are there ultimately to see that society is kept civilized. And sometimes even while we are drafting or even while discussing, we would know that this is not a winnable case. At least soften the blow. Softening the blow is definitely within our brief, I would say, because we can't exceed our brief. Our brief is to soften the blow most of the times. Then, another aspect which I would like to tell the entrance to the body is, academics may improve the literature of law, and corporate officers may enrich you, but ultimately law is what? Law delivers, and that delivery is possible only in litigation. Litigation is tough, but it is challenging and most satisfying, I would say. At the end of 50 years of practice, it is not how much I have learned. Of course, it is important, because otherwise, these days, the car you take to the court is also important. But the satisfaction is how much you have made the law work for the underdogs. Underdogs means I am not talking in terms of social justice or these issues. In a case, person who is suffering is the underdog. He may be the landlord also sometimes. Tenant, because of his unreasonable stances and unreasonable manipulations, he might have beaten the landlord also. The challenge is to make the law work for the underdog. That you do, then you will feel, even if you have to retire, you will say, yes, I have had my innings.
Sir, we are extremely thankful for you for this interview, for sharing so many things, enlightening us. Thank you very much.
Thank you. It is an opportunity for me to have, in fact, I could recollect so many things, and my own sufferings, they are nothing. That is what I realized today. There is a realization that every suffering is for an end and not an end itself. It is for an end.